Hello everyone and welcome to this new episode of the Privacy Rules Meet the Member podcast. Today I'm joined by our expert from Germany, that is Volker Wodianka. And I'm really pleased to have him with us today, since he is not just a partner of the German law firm SKW Schwarz, that is one of the prominent law firms in Germany, but he's also the executive director of SCHLUTIUS, that is a very interesting company in Germany that I would like to discuss a bit more about SCHLUTIUS and what it is and what you do and who you are. Volker, thank you.
Thank you very much, and I'm really pleased to be a new member of Privacy Rules. And actually, it's what makes it a little bit maybe different from other members. I work in two areas. I'm a data protection lawyer and partner of SKW Schwarz. So, of course, I did GDPR projects, no? The last 1.5 years, and before also to prepare my clients for the new law. But as well, and this is as my work of volume, what I'm doing, almost or more than 90% of my work is being a data protection officer, like a DPO, and being EU representative on Article 27 GDPR, which is formally a service and not like legal work as a lawyer. So that's the reason why we have these two legal entities. But SCHLUTIUS data privacy belongs 100% to SKW Schwarz, and I really think it's a good tool to cover all the needs that clients have that come to us, no? Whether they need only legal advice, DPO or EU representative. Yeah.
Thank you very much for this brief introduction, Volker, and it's really interesting to see how it's perfect. There is this perfect combination between the company and the firm that can in any time work together if needed, but also the relevance that you give to the role of the DPO and the EU rep, because it's a full-time service for sure, because it needs a lot of work behind it. So starting on that, I'm sure that you have lots of experience in terms of the application of the GDPR, and you know better than us that the GDPR somehow unified the regulatory frameworks in Europe, but is not the same in every country. So I would like to start warming up with you and see which are for you some differences that you have noticed with your experience in particular between Germany and other countries under GDPR.
Yes, actually I can, or I look back more or less like now 10 years in the like 100% work in data protection. So I don't do any like IT law by myself, but really, and in that time I also had already clients outside of Germany, because for instance, in Austria, they were looking to like the German structure of working with personal data and what are the requirements, because we had like already a long tradition of with the German federal data protection law in having a DPO in working with the laws, and had also kind of the rumor that we are very strict in Germany with the view on the rules in data protection. And some companies said, well, go to the German advisor, we are kind of safe even in our country. That was kind of what I experienced. One motivation for clients to come even to Germany to ask, can you be the DPO for us in Austria? So I have connections to not only Austria, but also to Norway and other countries. And there I saw, well, from 1995, of course, we had like the framework, no, of the European laws, and the directive from 1995 only gave a minimum of harmonization to the European countries. And to just give an example, what I experienced, what we know now, the data protection agreements, Article 28. Before they already existed, of course, no? Already the directive said when you outsource the processing of personal data, of course you need a certain musts of what you have to define there. And when we look very closely, and that's what I experienced in Germany, we always had like 7-8 pages of these contracts plus attachments, no? Technical organization measures, really a big contract. When you check that in Austria, for instance, also the recommendation by the authority was 3 pages long. And when you went to Luxembourg, it was a 1-pager with just 2 lines. Yes, we check technical organization measures, and we also cover data subject rights. So we do that, and that was totally fine until the GDPR. And so when we work cross-border, of course, we experience a lot of different learnings from the past, and the level when the GDPR came, of course, was quite high already. So many companies, of course, heard for the first time about data protection, also in Germany, that's true. But the rules that we had with the federal data protection law were already quite strict. And this is, I think, a main difference to other European countries that I experienced. In fact, yeah.
Definitely, this is for sure one of the main points of interest. There were very few other countries in which we have seen something similar. The other one member that said something similar was in Hungary, because also they had very strict rules, as probably in your case. So they were a bit more prepared. But it's really interesting to see how, and how you underline that every lawyer that has to work in Europe has to work with different authorities and in different frameworks that approach differently the data privacy sector.
That's another aspect. The structure of Germany is still federal with the data protection authorities. I mean, in France we have the CNIL, in Austria we have the Datenschutzkommission, and still have like a centralized system of data protection authorities. We have a centralized authority for the public area, but for companies it's still federal. So where's your residence as a company, that authority applies. And the funny thing is, of course, they're not always on the same page. So they have different opinions on certain subjects. So that makes it not a lot easier, but interesting and very vital. Yeah. Another aspect is, of course, the thing of the DPO. No, as you mentioned, in other countries, and I know in Poland, also in Switzerland, there were roles like a detection officer that always created also, or had the effect that you usually don't need to register your data processings at the data protection authority. So, and sometimes also ask for permission before you process certain personal data in cloud scenarios and so forth. And that was also not an experience in Germany, because companies even had a DPO or did not fall under these rules. So they always had experienced data protection as an internal compliance issue, no? And they never really were in touch with an authority. And that system now, in my view, is kind of the same in Europe with the GDPR. That is a harmonization effect, which is, I think, a really good news for our clients, because they can say, well, when I know about the impact assessment and when I know about data breach notification, I more or less have the two aspects where I have to somehow need to check whether I need to talk to the authority. But everything else is, of course, on the page of accountability. Documentation, there's a lot of documentation requirements, but it's an internal compliance issue, no? And the contact to authorities is kind of not existing. But as we know, data breach notifications, I did already a lot of them, and they already kick in when you lose your laptop or maybe your mobile phone, no? So
that's truly very interesting, Volker. Thank you, and to see that somehow you were already prepared, let's say, to GDPR. And yes, and I would like also to see, because this is another point that has been raised by your colleagues, that may be interesting to see if there are specific law, specific sector that are of particular interest. For example, in many cases, employee data, or the use from the human resources of the information. If in Germany also you have other specific requirements or some differences in respect to other countries.
Yes, I mean what we have is I mean the kind of the GDPR opening clauses apply in the field of employee personal data, but which is kind of a simple thing because more or less everything that is necessary. So necessity is the key word there. You are the employer allowed to process and collect from your from the employees. So when it's really necessary. You need it, then you are allowed to have it, and that's the legal base. Other than that, this is something special, but it applies only for insurance companies and special branches. Yeah, it's social data.
Social data. Yeah.
It's more or less it can be only a name or an address, but when a certain insurance company, for instance, they fall under the social acts and social data protection laws. When they process personal data of patients and people that are insured with their health insurance, then extra laws apply in data protection. And we have, of course, special laws for our churches. No, there's a special data protection law for churches. There's also special laws for telecommunications providers, of course. That did not really change the landscape of GDPR. That was already the case before May 2018. Yeah.
Yes.
And maybe the DPO is really something special in Germany with this number of employees. I don't know whether this is so familiar with the members. Mm-hmm. Or just to mention, we already have the requirement to formally have a DPO in the companies when with the 10th employee that processes personal data. Of course, the discussion is always who really do you need to count the people that work in the administration, or when you have a production line, do these people also count into the number of up to 10? And these discussions are a little bit difficult. But this was special before GDPR and remained that special rule after. So we don't check GDPR, but we have to look in the federal data protection law in Germany. And this number rises now in 2019, 2020 from 10 employees to 20. So somehow the pressure from smaller companies, from the mid-sized companies to say, well, we don't really formally want this requirement. That was a little bit lobbying that worked. But it's only about the question, do I need to appoint a DPO? Not do I have to follow the rules? No? Of course, we know everybody has to follow the rules. No?
And it's really interesting to see that the number of employees was pretty low, only 10 employees to appoint a DPO. Even 20 is still a pretty low number. So that gives us an idea on how strict are the rules in Germany. So why it's better probably to refer to someone that knows really well how it works.
Yeah. That's...
And in these regards, Volker, I would like to touch one last point that is always one of the most interesting, let's say, because it's the one related to the fines and the behavior of the data protection authorities in your countries, in particular after application of GDPR, of course, how things are going there.
Well, I mean, of course, my clients never have audits by data protection authorities. But sometimes I took part in audits already before GDPR, and just to give you like a feedback how the landscape changed with GDPR. We never touched issues like fines before. I mean, when you had like the pleasure to be invited or go to the authority to talk about the data processing with your clients, they had their remarks, they had some wishes, please make a contract here, inform better there, and these times when they were done, it was all okay. Yeah, they were kind of giving you advice. And that was always like the strategy and the politics of the data protection authorities. They were like, of course, not your friends, but they were the advisors and not interested in fines. That landscape changed now, and I'm sure that these are news because I also see the news when we have fines in Portugal, 400,000, or in other countries. That is really public. The Berlin authority, so again a federal, the state of Berlin, we had now 2 fines, largely over $1 million. There was one was with the think it's called Delivery Hero, like one of these food delivery companies. So they have a lot of B2C, like end consumer data, and they misuse that data. So they received $1 million fine. And the last one I was with in the rental area, the tenants, there were people that rent flats, huge databases with a company called Deutsche Wohnen. And they had no clear erasure concept. So erasure of personal data is really now a big topic. And the fine was 14 million euro. But when you look behind the curtain, I always realize that companies that really come in touch with fines, they usually had the chance to do something, write a concept, take action. It's usually not the first meeting then with the authorities that they have. My experience. I'm really interested to hear about members also in our new platform where you can discuss this. But I have, in my personal experience, very good experience with authorities. They also change their argumentation sometimes when we spoke with them, and they are very professional. Yeah. Maybe one last example, being professional. You are allowed as a company and me as an advisor to ask for advice, of course, to the authority, and ask them just, you don't have to say your name, you can just ask them a question. And I had a problem with a health data company, so in the sensitive area of data protection, and they received us and gave us advice how they see the topic. Now, how can we manage the risk and so forth. And they just also told us, we think you would in the future need to make it a PIA, a privacy impact assessment, which is of course a requirement by law, but they didn't say where's the PIA, show me your PIA. And I think as long as you have the same people in these places, you can expect that they're being fair, but they somehow, of course, are in competition now with other authorities. And the harmonization of GDPR also goes over the issue of fines, I'm sure.
Yeah, thank you. That's really interesting, Volker, for many different reasons. First of all, because data protection authorities are not monsters, are just people that want to protect data and want to help you doing better your work. So are the main advisors and the best advisor probably that the lawyers can have for very specific situations. So it's always good to speak with them. This is a common point from all the members of PrivacyRules, and that sure need to be underlined. And the other interesting thing from your point of view is the fact that having in Germany different data protection authorities you already have the experience that normally a lawyer can face when they have to work with different watchdogs, let's say, and now with the GDPR we can amplify this not just to Germany but also to other countries. So now it's even more understandable why you have a specific company for your EU rep and data protection officer work, because you know that you may also need to work with colleagues in other countries. That's maybe a good reason to be part of PrivacyRules, because you will have colleagues to refer for cases in other EU regions and countries, of course. So we ran out of our time, Volker. So thank you very much for this really interesting explanation on who are you, who is SCHLUTIUS, and what's happening in Germany. I thank you very much for joining us today, and I hope to see you again very, very soon.
Thank you very much as well, and I'm really looking forward to meet all you members.